You all know Thomas Bohan by now, and of course you know Mr. Krone, and Carrie had the pleasure of introducing Mr. Bohan, or Dr. Bohan, I apologize. But you didn't introduce yourself, so before we get started, perhaps you could do that.
Well, so I'm a professor at the University of Wisconsin Law School, and I'm a co-director of the Wisconsin Innocence Project. My tie to Arizona is that I went from Arizona to Wisconsin, and here I was the director of the Arizona Justice Project. Wonderful job, wonderful group of people. I came in just at the right time in which we got to design a DNA testing program. We got grant money from we were one of the first in the country to get what's called a Bloodsworth grant to look post-conviction back at murders and sexual assaults where DNA could show the perpetrators are the defendant's innocence. And we worked with Kathy and others around the state, and I think we involved the Attorney General, the Innocence the Justice Project, the DAs in the different counties, to really try to be extensive in looking at everyone who might have a claim where DNA could matter. And so we felt like it was important to do as thorough of a job as we could so that in the end we could say there's no one in Arizona who could be exonerated through DNA who we haven't looked at. I don't know if we accomplished quite that, but I think we made a pretty good run at it, and it helped cement a lot of relationships, I think, in many ways with people around the state.
I'd like to give a little bit of background, if I may, about the use of DNA, particularly as it may or may not relate to bite mark evidence in Arizona. Rick and I were speaking earlier, and neither one of us have ever had occasion to use bite mark evidence in a case, which is not to say that we haven't had bite marks as part of what happens to a victim in a case. We've never used it for identification. It's like friction ridge analysis. You know, so much of what is on the surface and what may be manipulated is not really something that you can use with any degree of confidence in making an identification. The quality of your fingerprint identifications depends upon the quality of your print, and similarly with bite mark evidence, so we never did it. But when we started doing DNA, and I had the pleasure or the curse of being the first prosecutor in the state of Arizona to actually present the first generation of DNA evidence in a criminal case. I was very fortunate that it was stipulated in, because there was DNA evidence that helped my case that was inculpatory to the defendant, and there was also some DNA evidence that was exculpatory to the defendant. So we stipped it. We brought the FBI in. I had to learn about science, and I didn't really like it. But you know, that was our first experience here in Arizona with it. And then as the methodology and the science and the forensic use of it became more prevalent across the country, got some other cases that involved DNA evidence analysis that was done by the FBI. And by this time, the defense bar had decided that DNA evidence was, in their words, junk science, and fought me tooth and nail for 2.5 years in a Fry hearing. We were a Fry state at the time, to keep the evidence out of court. After 2.5 years, and after the introduction of the first NAS report that related to the forensic use of DNA evidence, I got my evidence in, and the prosecutions went forward. But what was troubling to me was that this was happening at the same time Barry Scheck and others were starting the Innocence Project and were using DNA to exonerate persons. But yet the defense bar across the state was fighting us tooth and nail about the admissibility of it. And of course, we know that it's an excellent tool for excluding as well as including people. The results of that Fry process, and we're now a Daubert or Daubert state, so that process would have been a little bit different at that time, made me learn a whole lot more science than I ever wanted to, and I still remember it, sadly. I don't know if that's a good or a bad thing. But as you know, as I've said already, the development of DNA evidence has really changed the way we look at the presentation of cases. As Rick has said, what happened in Ray Krone's case, once DNA evidence, and based upon my and Rick's experience with it, when the saliva sample came up as not being Mr. Krone, we would have never gone forward with an additional prosecution. There is a forensic odontology certification group. It's called the American Board of Forensic Odontologists. Tom probably knows about it. And I went to their website this morning, and they have a whole new set of guidelines about what you can and cannot say about bite marks. You can say that the presence of bite marks may indicate a particular kind of violence associated with that assault, but the only place they talk about using bite mark evidence to identify a person is if there is a presence of saliva and you could use DNA. So Thomas probably knows this better than I do, but as a prosecutor, I would advise any other prosecutor to stay away from using bite mark analysis as a means of identification.
I'm very interested to hear that you have recent data with regard to what the American Board of Forensic Odontology says, because I have a particular interest in that. I am on the board that accredits forensic science certifying boards, including the American Board of Forensic Odontology. And the word on the street, we were the forensic, like FSAB, the Forensic Specialist Accreditation Board. We were being severely criticized because we had not taken away the ABFO's accreditation, given all of the material that was coming out about bite mark evidence just within, well, you know, the vice chair of the president of the White House Science, I was amazed that she came right out and stated this, said that the bite mark evidence is bogus, and I wondered whether she had some inside information of what the White House Subcommittee on Forensic Science had come up with that she was stating on. It was a very bold statement, but so anyway, so we've been trying to decide what to do on this. The person who's going to become president of the FSAB probably next year is in fact a odontologist. And I would say this about odontologists: almost all the work they do is identifying people. Mass graves, David Sen, who's the one I just referred to, has just come back from Tarawa, where they're working on identification of World War II American dead. Think about that. So that's what most of the work the odontologists do. The bite mark identification is something that was, it was sort of sexy, and I thought I'd grab people's imagination, and so it sort of rose, and now I think it has fallen. And so I'm very, very happy to hear, and I'm going to check as soon as I come home tonight what they are saying, because that's an important change.
Carrie?
So I'm glad you mentioned Bereshek and the DNA, the idea of DNA being used to prove that someone didn't commit the crime for which they were committed, because I really believe, and it's not just because I have a lot of admiration for Bereshek and Peter Neufeld, but I really do believe that their idea of using DNA in that way has created, if not fueled, a revolution in the criminal justice system that can't be understated. It is the foundation for questioning all the rest of the forensic sciences. For goodness sakes, we thought bite mark evidence was, you could say it was a match. The only reason we don't think that anymore is because of DNA testing. The only reason we don't believe a lot of things that we used to believe about the certainty of evidence in trials, hair analysis, blood analysis in different cases, all sorts of fingerprints even, is because of that work of using DNA to go back in and look at old convictions. So I don't think it can be understated, the power of DNA to change the way we look at everything and question everything. So what do we do now? Now that the National Academy of Sciences has said that almost every one of the forensic sciences is unreliable or invalid in matching a bit of evidence to a particular person or perpetrator, what do we do in the criminal justice system about this? What do we do knowing that thousands and thousands and thousands of convictions have relied on that kind of evidence? What do we do knowing that there's not DNA in many of the cases that we have? either it doesn't exist or it didn't play a role in the case. So whole things like arson, there's usually not DNA there, but we know that for years it was all about myth, just myth. No scientific foundation to any of it. What do we do about that? And that's where my interest is. And because I've been told this is a workshop, I sort of just wanted to throw it out to you all. I mean, if you've run in a conviction integrity unit, what do you do knowing this? What do you look at? What do you categorize as things to look at? How do you go forward knowing that we didn't know? How do you feel comfortable with it as a prosecutor? How do you continue to prosecute a case in which a bite mark is there? I mean, prosecutors are still doing it. How do you prosecute cases where the science is so questioned, like in shaken baby abusive head trauma cases? What do you do? And maybe some of you have ideas about how to go forward. I'm still sort of, this is why I'm in this area. It's relevant and it's exciting, and I think it is revolutionary.
Well, I can speak to what I would do. First, I would point out that the NAS report is vastly overstated in its conclusions and is a very political document in my judgment. Much like the very first NAS report that related to DNA. There are two NAS reports back in the 90s that related to the admission of DNA evidence in a criminal case. The first report said it's bad, particularly the population genetics part. Nobody knows anything about population genetics. That's the science that we use to determine the relative rarity of the coincidental leaving behind of some DNA evidence. The second NAS report that came out 3 years later said DNA is wonderful, it's great, let's use it as long as we have disclosures and protocols and standards, etc., which we all now have. There has been a criticism of forensic science for 20 years. And it comes largely from law professors, no offense to law professors, and other academics who do not and have never set foot in a forensic science laboratory. The very first members of the committee, the NAS committee, did not include one practicing forensic scientist. They finally realized that that was kind of a problem and added one halfway through their process. There were no prosecutors on it, and all the literature they reviewed came from those critics who had been around for 20 years. And you know, I chuckled at your comment earlier about the SBS literature. It's the same thing in the forensic science criticism. They all cite each other. I mean, so to say, so I have to quarrel with Carrie, as much as she's my friend, that everything is invalid and unreliable. One of the things that the report did not do was make any effort to really look for 100 years of literature in the forensic disciplines that relate to validity and reliability studies. And that's how we are successful in surviving Daubert or Daubert challenges, to answer a question from earlier in the day. We bring on our scientists in and they testify about all the reproducibility studies and validation studies that they have conducted over the course of utilizing this in a forensic context. And I know Tom wants to jump in.
You bet.
And because there's no one else doing it. You know, if you have an interest in trying to exclude an individual from having left a fingerprint or include an individual from having left a fingerprint, what college is going to do that for you? That's not where their interests necessarily lie. So a doctor, a scientist 100 years ago developed that process, and that's been repeatedly validated in forensic contexts since then. Now, which is not to say that we don't, and forensic scientists don't support continuing research. We do. We'd be grateful for it. We'd be happy to do it, and we're happy to participate, and we want there to be more of those kinds of studies so that we can demonstrate to the community and the public safety community and to the folks sitting in this room that we can have confidence in our criminal justice system. So when you as journalists, and this happened when the NAS report came out, all the journalists reported the NAS report with the executive summary with headlines that says, all criminal, I'm exaggerating here, but all criminal convictions suspect of faulty forensic science. Not one journalist picked up the phone and called a prosecutor, called a forensic scientist, called the DPS lab to ask for a differing perspective or an explanation for what it really means. And I think that's, no matter what the subject is and no matter what viewpoint you're given, your obligation to your readers or your, whatever they do now, listeners, your bloggies, I don't know if that's a word, but is to make sure that not only two, there may be three varying perspectives on this issue to educate the public and to educate yourselves. And that may mean you have to read scientific literature. It's hard. But you can't just take at face value, and as Thomas said this earlier, what somebody tells you about a particular discipline without doing some legwork yourself. Sorry, that was my
Absolutely. I think I probably have read the NAS report more times than anyone else in the world. And the reason I say that is because I wrote a book review on it. And when you're going to write a book review on something, whether you're going to praise it or whether you're going to criticize it, you better be right. And so I read that sucker over and over again. I did have a criticism, but not along the lines Kathy's talking about. I actually was going to correct Carrie. The report, on one point, the report does not say these techniques are invalid. The report said they have never been validated. Yet. They have not been validated. And that's a very important distinction. Now, the fact is that the people who are true scientists working in this field, and I consider myself one of them, were not surprised because we knew this. They had not been validated in the sense of what we consider validation in science. I met with, when the dysfunctional Congress was trying to develop some response to the NAS report, I went to many staff meetings about this subject. The first staff meeting I went to had to do with the bill that Senator Leahy wanted to introduce, and the staffers had really done a lot of work. It was a fairly good beginning. I went there. There were 16 people in that room. I remember I sat next to Peter Neufeld, I don't know why I mentioned that, but I sat next to Peter Neufeld at that meeting. I was a name dropper. I know I was a name dropper. There were 16 people there. I was the only person who had ever done any science. And yet we had all these people going around the room, and it was heavily tilted toward law enforcement and toward district attorneys. And I know Peter Marone from the Virginia Crime Lab. He was there, and he said, "Oh no, we've got all kinds of studies that have been done over, as Kathy says, over the last 100 years. People just have them in their drawers, and so we'll have them pull them out, and we'll peer review them." That's not the way peer review works. Peer review works. The peer review is not the fact that a couple of guys that the editor knows get sent the manuscript, and they look it over and see if there's any gross errors before saying it should be slightly changed or it should be rejected. Peer review occurs when an article or when a study is published in a peer-reviewed journal, as they are defined by what I've just said, and then people in the discipline take that seriously and review it. So the peer review takes place after it's published, and so there's no way in which we can have people pulling stuff out of drawers that they've had them in for the last 20 years, and then we will peer review them. So I disagree completely with you, Kathy, on this. I will agree on one thing, though, and this was that the study had very serious limitations. I mean, it just was, I think $2 million was allocated to that, and I certainly know the politics behind that. We'll talk about that later. The politics behind it were, I think, more interesting than the one that came later. They were not able to do, within the time and money limitations, do what other National Academy of Sciences committees had done. When they wanted to look, for example, when the FBI asked them to look at polygraphs to see whether they had been validated for screening employees. They asked all the people who supported polygraphs to submit the studies that they said supported it. And they went through all of these studies. I mean, that's the way you approach the determination as to whether something's been validated. So I agree, they did not have enough time to do the study that would allow them to definitively say there's never been a validation. But I will say this, that, I'll repeat this, that people in the field who were scientists were not surprised by the conclusion, because that has been my observation too. The studies have not been validated.
Ray, yeah, I would like to recognize you and
Well, I thought it helped some of you out there that were like me, that like, bite mark, I didn't bite nobody, what are you talking about? Are you picturing in your mind of a bite mark? You all probably seen fingerprints somewhere on TV. I think fingerprint looks like a nice round thing. Some of you might have, like me, I'd actually do one and it's a nice clear fingerprint. And so I want to clear this up for you. A bite mark's not like something you just chewed a piece of gum and you got to pull it. Not like you just bit into a peanut butter and jelly sandwich and there's each and every full curve of your mouth and each and every. That's not what we're talking about here. That is the rarity. They've had everything from bite marks being on the edge of the plastic of a window. In my case, it was on her breast. This is not a perfect identification. It's not great. In my case, you know, we all have, I think it's 32 teeth. Divided upper and lower, and they identified one tooth. In my case, there was 3 or 4 marks on the top, and then there was just kind of like a red scrape on the bottom. And they were identified. The expert that testified said what matched tooth 14 and that tooth 13 or whatever. My front one was twisted and turned, and that matched this one. And then there was another one over here that matched. And at the bottom, because I had a bridge that was there, that they were close together, that showed that same scratch mark that was made from it. And this is how this is being described in this court of law, and I'm sitting there all dumbfounded. How can this be? My first trial went pretty fast. We had no bite mark expert. They did not allot us any money. It's great to hear what Pima County is doing for the people. They did allot us no expert. They said $2,000 hire an expert. My actual court-appointed attorney got somebody to put the braces on his child who looked at it and said, well, I don't know anything. So he was never using my first trial. But by my second trial now, we know a little bit about the science here. My attorney actually, when it came down, and a lot of times once you imagine a court of law, you have an expert testify. They might go all day long with their story, and they might make a whole lot of statements that, all right, you want to get up there as a defense attorney, correct? But you ain't going to get the chance the next day. And the jury already heard whatever the story was being told there. So my attorney finally got to cross-examine this expert. My attorney brought out a big blown-up picture. It was actually from the autopsy. You could actually still see where they'd opened up the body, the rib cage. And here was this mark where this expert was identifying this bite mark in the breast, and my attorney has zoomed in over there and showed this very picture. The first picture was the body found at the scene before the autopsy was marked. And there's no mark there. There's actually only, you could count about 5 marks around the breast. Well, and he shows this picture of the autopsy. Now there's this 6th mark that's over here at about 9 o'clock area, identified as my tooth number 8 or whatever the heck it was. And my attorney asked him to explain what that mark was and how that matched. He said, well, absolutely, that's Crone's tooth, right? And he's going through all. Then my attorney brings back the original picture of the victim's body laying right there at the crime scene, right where it's found, and that mark's not there, and asked him to explain that. Well, now that would have been something that should have been on video, because it was great saying, well, you know, and the prosecution objects, and he stops the trial right there, and they have the jury dismissed and left out, and comes back in later on. It ended up, they actually brought somebody from the ASU's art school. If you go there, do you ever see that ink block that, like, it's a black picture, and one way it looks like an old woman's face, and the other way it's a young, pretty girl's face? Have you ever seen that? They brought that out to explain how that mark suddenly appeared and disappeared. It was all in your perception. It was all how your eyes could see it or not see it, and explain this away the mark. Actually, later on, as you heard about the Dr. West story with the teeth, we actually ended up with a picture. They had the cast of my teeth on this woman's breast, which eventually they actually exercised, circumcised, whatever the breast area, the part that was actually taken and made a cast. That disappeared, but it actually showed a picture of the local medical examiner with my set of dentition on that teeth pulling on the skin. This is what we're talking about. Is this junk science? Is this true science? Is this something of value or is it not? And I just wanted to get that in for y'all so you can imagine it's not a perfect drawing of your teeth. It's not like your dental chart when you go to a dentist. In some cases on such small areas, small parts, it's only 1 or 2 teeth that they're identifying. They're actually saying that they could see a cavity in some of them or a missing nick in it, and that positively identified as being that person. That is actually what a lot of these cases, when we talk about bite mark cases, are actually dealing with, folks. It's not 32 teeth in your mouth.
No, Ray, you're absolutely right. I mean, I think we all would agree with that, and that clearly is another example of professionals behaving unprofessionally, for whom sanctions should ensue, or should have ensued. What would you do, though, Ray? I mean, I think that...
Go to extreme makeovers?
So, in terms of, you know, using your case example or others that we've discussed here today, in terms of how would you like to see the system be different? Better trained defense attorneys? I think Tom and I would agree that sometimes that's a problem.
Again,
and judges,
it's so that we are, in order for our democracy, our country, we allow it to be regional, we allow it to be state, we allow it to be counties, how different counties run. And that's unfortunate that it is really depending on what county and what jurisdiction you're in. that how well it is run. I actually would like to turn that around and question you. I've wondered how receptive was Maricopa County to opening up an integrity unit like y'all did here at Pima County. I mean, again, it's an area, it's an attitude of what that region, what past directors were. As far as fixing it and correcting things, I think it's difficult, but I think we're well on our way because another generation is coming up, the youngsters, the youth, the media attention is coming out. That certainly has the public up in arms about it. And again, for groups, like you said, originally you were like the 5th in the country, it's how many now?
Rick, 11?
We were 15 to now
15.
And I'm-
20, 21 or so.
I'm sure you expect to see that growing exponentially each year, probably, because it is a good thing, and it is the right thing to do, and there's gonna be resistance from some of those folks out there, but I think that's one of the steps, and I don't think anything fast could happen in our justice system to make it more correct, except get rid of prosecutor immunity. And again, as I'm thankful, so thankful you come to hear you, I'm not against prosecutors, I'm thankful for what they do out there. It's those ones and few, and in any profession, they're gonna be there, that the profession itself doesn't clean up its own mess. And that's the one thing I think of prosecutor immunity would make a big difference. And in the iPhone case, I'm happen to be familiar with that, so people prosecute. He was running for office, he was having difficulty in that area where it happened because it happened to be a minority area, and he wasn't getting a minority vote. He thought that this case right here would pop him over the edge and get him reelected, and that's why iPhone pursued that, and that's a fact.
No, I don't disagree with that. And just to clarify for y'all what Ray means by prosecutorial immunity is that by Supreme Court decision and other court decisions, prosecutors who are acting within the confines of their profession are immune from prosecution or charges for making mistakes. So I have an ethical obligation not to charge a case unless I can prove it beyond a reasonable doubt. Right? If I violate that, I could charge somebody, but there's no consequence to me if I make a mistake in that charging. And it could just be I'm an inexperienced attorney and I'm not really sure exactly what my obligations are to establishing all the elements of offense, so I may not be doing it on purpose. If, however, I am engaging in a series of what we would call not just making mistakes, which we all do, but intentionally depriving a defendant from his or her constitutional rights, which results in an erroneous conviction, both Rick and I agree that we think there should be criminal consequences for that. Right now, because of prosecutorial immunity, that's not happening. So that's why Nifon can get disbarred. He's subject only to discipline by the state bar. Harry Connick Jr.'s dad did something horrible in New Orleans, withheld some evidence, and because of prosecutorial immunity, and that resulted in an erroneous conviction, nothing can happen to him, and I just think that's wrong. Which, incidentally, to answer another question, dismissal for reasons in the interests of justice, you're absolutely right. It means because we have to do the right thing. We've made a mistake and we need to fix it.
Interestingly enough, about the Maricopa County case disposition worksheet, which was the attorney's work product, and also with the prosecutor notes, the civil attorney had subpoenaed that and was successful, and that's how I got it. However, the Maricopa County Attorney's Office tried to claw it back.
Well, I can't speak for the Maricopa County Attorney's Office, so Ray, to answer your question about whether they would do a conviction integrity unit, that's a question that a journalist may want to ask Bill Montgomery one day.
I can say that I was very pleased with the Maricopa County Attorney's Office and the steps they took against the arson investigators. While most wanted them prosecuted, he managed them to Brady list, he refused to take any of their cases. So they really did do a good job with that, and they also were subject, they engaged in withholding exculpatory information, evidence against Barbara Sloan, and it was clearly written in the prosecutor's notes.
Mea culpa, but, you know, don't do it.
A lot of
That's what we're trying to say.
Yeah, a lot of it's a pattern too, because that was Romney back then. Was it right, Romney, or
Rick Romley?
Romney was, and that was who was the head DA when my case going in. A lot of these other cases happened, and that's a continuation of the policy. Who's in there now is just that's the people that worked their way up through that office that are now in charge of Maricopa DA. But that was a lot of his policies and practices come from him, and that is an elected position also up there, as you know. And he did have political aspirations. He was looking to run for Attorney General and governor.
Tom, you have
I
one?
just wanted to mention that there really is a significant imbalance between the responsibilities of prosecutor and the defense attorney in our criminal justice system. The defense attorney's obligation, I mean professional obligation, ethical obligation, is to do everything he or she can to get his client relief, to get his client acquitted, his or her client acquitted, short of putting someone on the witness stand that he knows is going to.
Right, within the bounds of the rules.
Within the bounds of the, oh, yes. But I mean, in terms of, you know, if the defense attorney gets an expert who is willing to say whatever the defense attorney wants him to say, but our system requires that the prosecution show beyond a reasonable doubt, and it's the defense attorney's role to put that prosecutor to the test. So yeah, go ahead.
I think the expert testimony thing is one of the things our justice system and uses. Again, I'm way overwhelmed here with actual professional experience. Me, just it's about my story, it's about my personal story. When you have people who are working every day for other people's own personal stories to save lives. But I think one of the most confusing things and troubling things about our justice is this expert testimony thing. Because if you got enough money, your prosecution is going to have one expert on this specific subject, whatever it might be. There's going to be an expert for the prosecution, and there's going to be an expert for the defense. And if you actually sit down here, they got a 180-degree opposed opinion about what the facts actually mean. And they both have the great credentials, they both have the great ability. And now it's supposed to be left up to a jury who has no training whatsoever in this to ascertain from whoever looked the best, whoever spoke the clearest, whatever they're going to use, because they're certainly not going to weed through all that scientific evidence. And they're supposed to decide now who's telling the truth, who we should believe and who we shouldn't. If it's truly a science, if it's truly worthy of being in our justice in a criminal determination setting, I think it ought to be easy enough to find one expert ought to be able to come in, and it's either right or wrong. It shouldn't be the adversarial. That's not what I think our system will want allowed to do, but I think if it really was a true science, that each and every one of them, just as it's supposed to be a passive reliability test, the old prior rule, each and every science that comes up and looks at that evidence will come to the same conclusion no matter what. It just doesn't happen. We got experts who are not going to agree on anything, and yet they're being paid, and a jury's supposed to left up to them to decide who was telling right, who should be.
Well, Carrie, to piggyback on that, hey, how much time do we have?
Well, originally we were going to stop at 3, but this is a good discussion.
Let's talk a little bit about ETL drawer and contextual information, because I think what Ray is touching on is where your experts come from and what information are they being given before they come into the courtroom and testify that may or may not influence the opinion that they wish to give. For our profession, sometimes, Carrie probably disagrees, Tom, as well, but we tend to think an expert is anybody who comes from out of state. You can't believe anybody who actually works in your own backyard. They can't be an expert. So we have forensic scientists who do work, and we take great pains not to give them the facts of the case so that they can come to a conclusion without a contextual bias. Sometimes what happens is that the defense attorneys will want some evidence tested that we don't think, or the lab doesn't think, is probative. And we'll go and we'll sit down with the scientists and say, we want, and the defense will say, I want this item of evidence tested for DNA. And the scientists will say, it's not going to tell you anything, and here's why. Okay? That sometimes is contextual information that they have to have in order to answer those kinds of probative questions. But fingerprint examiners should never be told what the facts of the case are and who's confessed or who hasn't confessed, which is why we have people who collect the fingerprints. They are not the same people who analyze them. And the initial analysis is confirmed not once by an independent examiner, but twice by an independent examiner, and then sent to the defense so the defense can hire its own independent examiner, who may or may not dispute that there has been an identification on that fingerprint. But there is a tendency among defense experts who are being essentially paid to provide an opinion. To that extent, from our perspective, that's why they disagree with what people in the science laboratory will say. Because they have been given contextual information that our scientists have not, which is why we can cross-examine them. So to the degree that this is an adversarial process, we are not in the position of being able to redesign the entire criminal justice system to take the adversarial process out of that. That process is designed to allow a jury of the defendant's peers to ferret out the truth. And some of the stuff may be gobbledygook to them. We try to present it in a way that it isn't. make sure that our scientists actually talk in real speak instead of constant polysyllabic words, so that juries can understand that. And then it is up to the lawyers in the courtroom. Prosecutors have been bad in the past about overinflating the probative value of forensic evidence, and that's one of the things the NAS points out, and rightfully so. To say that when your hair expert has said that, yeah, this hair is consistent, it could have come from the defendant, but doesn't mean it did, and then I stand up as a prosecutor and say, you heard from the forensic scientist that was a match. Okay, it's up to the and that's wrong. I'm misstating the evidence. That's an ethical problem. I shouldn't do that. But it's up to the defense attorney at that point, if I've done that, stand up and say, objection, that's misstating the evidence. The judge corrects the jury, and I look like an idiot, and I have to correct myself. That's part of what that adversarial process is, and I think it works quite well in the scientific context. Well, because we have to educate jurors about what's happening in the scientific world, and they understand that there are differing opinions, and it's the defense attorney's job and my job to point out the basis for those opinions. Are those opinions based on reliable methodology? I may say there are. The defense attorney may be able to point out through a defense expert that no, the methodology is not reliable, and here's why. And we lose. That's, how do you change that now?
Well, you point out one problem that the NAS and others have recommended a solution for, and that is that the state has all the power. In a criminal prosecution, the crime lab is operated by the state. They have access to the crime lab. They have access to the forensic scientists, I'll say. They control the evidence. The defense does not get to go to the, you don't get to go to the autopsy and participate. You don't get, access to evidence until the state allows you to have access to that evidence. I've seen DNA reports where they give contextual facts on them, which I can't understand why you need to say. We're trying to this person was in this seat of the car, and we want to see if this person's DNA is on this and that. DC now has an independent crime lab. Defense and prosecution submit stuff to the crime lab. There's no reason the state should have total control of the evidence in these cases. There's no need in DNA testing cases for the state to have a monopoly on the testing. And you see how it plays out in the courtroom. When the state brings in a forensic scientist who's looked at the fingerprints or the DNA, they're just, doing their job. Then the defense has to pay an expert to come in to talk about that without really access to that lab and not being in that lab, not being part of that process, to testify about how the methods were unreliable. And then the prosecutors spend a lot of time talking about how much money that person made to come in and testify to that. What do you think the jury thinks? What conclusion do you come to? Who? Hired guns. Hired guns coming in from out of state to talk to you about how the state didn't do its job. Who's got a motive and what is that motive? The motive of the state's experts is to solve crimes. The motives of the defense experts are to make money off of just, trying to trash the state's evidence. And so this system in which we have an adversarial system, yet all the resources are controlled by the state, is not working. It really just isn't working.
Well, Carrie, I have to disagree with that, because every time we have a DNA case, a fingerprint case, or a ballistics case, once the initial work is done by our laboratories, the defense attorney is free to come and pick up that evidence and take it to their own expert and have it re-examined. Okay? And that is the way it should be done. Not just hire somebody to come in and say, I don't like the way they did it. Then do it yourself, and the state and the taxpayers are going to pay for it.
But you could have an independent lab where either can submit, where the state and the defense can sit and look at the evidence and decide what to test.
We do. I mean, we have a lot of private labs in DNA work, and a lot of them are not accredited, and they don't really do very good work. So that's the concern I think that a lot of people have about an independent laboratory is who is in charge of making sure that that's run according to the standards that the DNA Advisory Board, just to use that as an example, has developed.
Well, I mean, well, DC is a model now, and we'll see how that works, but you can set up an independent lab, independent of the prosecution, independent of the police.
And who pays for that?
Well, the state does, but it's independent of the prosecution and the police. I mean, it's happening, and it's been recommended, and it happens in other countries.
I think that one of the things that's happening now is that there is a national commission on forensic science, where a lot of these kinds of things are being discussed, and there may be some move in that direction. I think that's increased costs to the taxpayers. I can see arguments on both sides. But I think that as Ray pointed out a little while ago, it's going to take a long time for that commission to sort of sort out all of these questions. And in the meantime, it's up to us to make sure that we're still doing things ethically and with integrity and to the best degree that we can.
Just think of Ray's case if a bite mark had been taken and gone to an independent lab where the analyst had no.
It did. The court appointed an independent bite mark examiner who came to the same conclusion as the one hired by the Maricopa County Attorney's Office, and unfortunately, the defense was not given the one that Skip Sperber did, which had been suppressed by them. So an independent lab is not necessarily going to make things, that's not going to make it an ideal world.
Let me play devil's advocate to Carrie here. The Tarrant County Crime Lab does accept from both defense and prosecution. Ron Singer is the head of the lab. And, but he says, but we'll give a full report. I mean, very often, again, because of this imbalance between prosecution and the defense may not want a full report that's made public. You might want to have the option to maybe not
disclose that?
Disclose that.
Yeah.
And so that, of course, so I guess my question then is, would that be something that would be acceptable or not? I mean, this, the model they have in Tarrant County in Texas.
Well, I don't think it's the most ideal. I think a crime lab in which the analyst doing the analysis doesn't know who it's coming from is the model.
Oh yeah.
I think it's a pretty major change too. We're talking about this definitely rearranging our whole justice. But there are some smaller stuff that I'm aware of. Another earth-shattering one for me is I'm sitting in the courtroom, and you both can address this, but as you heard, expert testimony. Somebody gets up there, and it's actually in this case, Ray Raza gets up there, and he's asked by the prosecutor, now when you examine these dental teeth, what was your conclusion? He said it's consistent with Mr. Krone. How can that be consistent with me? You all think consistent, right? That's like a match, right? Well, let me explain to you, or at least I'll give it close anyway, and then I'll let you both. Consistent appearing in scientific speak means it's more likely than not. Like it's like 51% instead of 49. Really. Go on, what? And they changed that. If you tell me it ain't true, because it went from consistent it went to beyond medical certainty to a match. And you know darn well that bite mark experts are not allowed to say match.
I was involved in a hair identification case, 1982. I wasn't the one that testified, but I got in an expert. This is for the defense from using a NASA fibers expert and so forth. The FBI had done the analysis and said, yes, the hair they took from the victim is consistent with coming from the defendant. So, and even they sent up the FBI examiner to say that. So the defense expert gets up and he says, is it consistent with coming from the defendant? Yeah, and from 50 million other people in this country. So that's what consistent.
It's not
it's not exclusive.
Yes,
It's not exclusive.
I'm standing up because I have been told we're done.